My name is Severina McGill and I teach at Jindal Global Law School. This module is for the E-Pathshala UGC. This module will continue our examination of national legislative frameworks and will examine the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act. By the end of this module, the reader should be able to acquire an understanding of the constitutional provisions relating to sexual harassment of women generally and at the workplace specifically. They should also be able to identify the Vishaka guidelines and how these created responsibilities for states and employers. We will also identify the important provisions of the Sexual Harassment of Women in the Workplace Prohibition, Prevention and Redressal Act from 2013. This module will enable the reader to critically understand and analyse certain contentious questions pertaining to sexual harassment in contemporary India. The right to life is guaranteed under Article 21 of the Constitution of India. The scope of Article 21 has been expanded over the years, and it unequivocally interprets the right to life to be a right to life with dignity. The fundamental right to perform any occupation, trade or profession under the Constitution of India is dependent upon the availability of safe working environments. Further, the right to gender equality encompasses protections against harassment of women at the workplace, which can also violate women's rights to life and liberty and correspondingly the right to work with dignity. Moreover, the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, to which India is a state party, recognises the right to work as an inalienable right of all human beings and requires all state parties to take appropriate measures to eliminate discrimination against women in the field of employment. This is in order to ensure equality between men and women. Today, a large portion of the workforce is constituted of women. There has been a need to facilitate a safe and enabling working environment for women, and for this purpose, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act from 2013, hereinafter the 2013 Act or the Sexual Harassment Act, was passed. The passing of this Act was not a simple act of the legislature and Parliament. The journey has been one of hardship and perseverance. The present status of the protection against sexual harassment which the law provides is primarily by way of constitutional guarantees, criminal law provisions and the 2013 Act. Legal protections may also be found in international human rights law. However, as India is not a state party to the optional protocols that establish an individual complaints hearing mechanism, the mechanisms are unavailable as a form of redress. This module will give an introduction to the issues pertaining to sexual harassment in India. It will give a historical overview of the development from the Vishaka Guidelines to the 2013 Act. The module will also delve into key provisions in the 2013 Act and proceed to discuss significant developments since this Act has come into force. A world without consequences causes escalation of criminal activities and criminal behaviour. Staring, lewd remarks and touching have all become a part of a woman's everyday life in India. Women have chosen to ignore and dismiss these incidents as routine so that they may go on with their life. These instances also permeate the working life of women. India seems to have a long-standing tryst with sexual harassment. Though the term sexual harassment at the workplace may be said to have come into popular usage very recently, the issue has existed as long as people have been trying to work. The issue of sexual harassment at the workplace may affect both men and women. However, in India, the law only pertains to women. The Indian National Bar Association, or INBA, recently undertook a survey of 6,047 male and female participants. The survey reported that 38% of the participants had faced harassment at the workplace and 69% did not complain about it. There are several reasons why sexual harassment goes unreported. Women may fear ridicule, further harassment, a lack of support in ensuring cases are investigated, and in extreme cases, the loss of her job. One such example is of a case pertaining to Air India. In 2012, an employee working at a restaurant at the Indira Gandhi International Airport in New Delhi filed a case against a senior Air India official, accusing him of sexually harassing her. The employee worked with a firm to which Air India had outsourced work. The woman said the official showed her pornography clips, nude photos, and made physical advances towards her. Whilst the police launched a probe into the case, the woman said her complaint to the Assistant General Manager at Air India was ignored. When she complained to the Assistant General Manager, they said she should take a 15-day break and that she would be given a job at a different department. When she went back to work, the security staff refused to let her into the airport. She says her job was terminated because she had complained against a higher official. The woman's testimony demonstrates a significant social barrier that prevents effective reporting. The following section explains the historical overview with constitutional provisions and case laws. Part 3 of the Constitution of India guarantees certain fundamental rights to all Indian citizens. Some of these rights are guaranteed to every human being, regardless of whether they have citizenship. A number of these rights may be relied upon to promote the elimination of sexual harassment at the workplace. The most important of these is guaranteed in Article 14, Equality before the law, Article 15, Prohibition of discrimination on the basis of sex, and Article 16, a right to equality in all matters relating to employment. Articles 19, freedom of speech, and 21, the right to life, are also relevant. The objective of the law in these provisions is to remove the formal as well as substantive notions of inequality. Discrimination on the grounds of sex has been the subject matter of several cases before the Supreme Court of India, both with regard to discrimination at the workplace and otherwise. In 1996, the Supreme Court held in C. Masilami Mudaliar versus the Idol of Swaminatha Swami Tirikoil that every woman is entitled to the elimination of gender obstacles and discrimination. The case further recognized that the state has an obligation to eliminate gender-based discrimination and to create conditions and facilities conducive for women to recognize their right to economic development whilst enjoying social and cultural rights. Article 19(1)(g) of the Indian Constitution guarantees to everyone the right to practice any profession or to carry out any occupation, trade, or business. Gender discrimination against women during employment violates a woman's freedom to carry out her occupation. While several case laws look at gender discrimination as violating women's right to work, the decision of Vishaka versus the state of Rajasthan was the first to recognize that one of the consequences of incidences of sexual harassment at the workplace is a violation of her right to work. The fundamental right to carry on any trade, occupation, or profession depends on the existence of a safe working environment, something which cannot exist when sexual harassment at workplaces exists. Women are often particularly disadvantaged when it comes to sexual harassment because they are disproportionately affected. Further, Article 19(1)(a), (c) and (d), which guarantee freedom of speech and expression, the right to form associations and unions, and the freedom to move freely, may also be violated due to sexual harassment at workplaces. In the landmark case of Vishaka and others versus the state of Rajasthan and others, decided by the Supreme Court on the 13th of August 1997, the court decided to fill the vacuum of specific legislation on how to prevent and respond to sexual harassment at the workplace by passing guidelines. In the absence of legislative measures, the need to find an effective alternative mechanism was found to be of urgent social need. The immediate cause for the filing of a writ petition under Article 32 of the Constitution of India was an incident of brutal gang rape of a social worker in a village in Rajasthan. The petition was brought as a class action by social activists and NGOs with the aim of focusing attention towards the societal aberration and assisting in finding a suitable method for the realization of a true concept of gender equality and to prevent sexual harassment of working women in all places through judicial process to fill the vacuum of existing legislation. The petition specifically prayed for the enforcement of fundamental rights of working women under Articles 14, 19 and 21 of the Constitution. It was stated that such incidents result in a violation of a woman's fundamental right under Article 19(1)(g) to practice any profession or to carry out any occupation, trade or business. In view of the above, and in absence of enacted laws to provide for the effective enforcement of the basic human right of gender equality and the guarantee against sexual harassment and abuse, particularly at workplaces, the Supreme Court gave guidelines and norms to be observed at all workplaces or institutions, until a proper legislation was enacted for the same purpose. These guidelines came to be known as the Vishaka Guidelines. The guidelines and norms created as part of the Vishaka judgment drew from the definition of human rights as under Section 2D of the Protection of Human Rights Act 1993. It elaborated the duty of the employer or other responsible person in workplaces and other institutions to prevent or deter the commission of acts of sexual harassment and to provide the procedures for the resolution, settlement or prosecution of acts of sexual harassment by taking all steps required. The Act defines sexual harassment as, for the purpose of this, sexual harassment includes such unwelcome, sexually determined behavior, whether directly or by implication, as physical contact and advances, a demand or request for sexual favors, sexually colored remarks, the showing of pornography, and any other physical, verbal, or non-verbal conduct of a sexual nature which is unwelcome. The preventive steps prescribed include the following. A. To the express prohibition of sexual harassment as defined above at the workplace should be notified, published, and circulated in all appropriate ways. B. The rules and regulations of government and public sector bodies relating to conduct and discipline should include rules and regulations prohibiting sexual harassment and provide for appropriate penalties in such rules against the offender. C. As regards private employers, steps should be taken to include the aforesaid prohibitions in the standing orders under the Industrial Employment Standing Orders Act from 1946. D. Appropriate work conditions should be provided in respect of work, leisure, health and hygiene to further ensure that there is no hostile environment towards women at the workplace, and no employee should have reasonable grounds to believe that she is disadvantaged in connection with her employment. In addition to prescribing the possibility of pursuing appropriate criminal remedies and initiating disciplinary actions, a detailed complaint mechanism was established. The complaint mechanism states whether or not such conduct constitutes an offence under the law or a breach of the service rules. If it does, an appropriate complaint mechanism should be created in the employer's organisation for redressal of the complaint made by the victim. Such a complaint mechanism should ensure a time-bound treatment of complaints. The complaint mechanism referred to above should be adequate to provide, where necessary, a complaints committee, a special counsellor or other support service, including the maintenance of confidentiality. The complaints committee should be headed by a woman, and not less than half of its members should also be women. Further, to prevent the possibility of any undue pressure or influence from senior levels, such complaints committee should involve a third party. This could either be someone from a non-governmental organisation or another body who is familiar with the issue of sexual harassment. The complaints committee must make an annual report to the governmental department concerned of the complaints and action taken by them. The employers and person in charge will also report on the compliance with the aforesaid guidelines, including on the reports of the complaints committee to the government department. Among other guidelines, the court also detailed norms pertaining to spreading awareness of the right of women in the workplace, as well as the state providing support to ensure that these guidelines are complied with in all workplaces including within the private sector. Although the Supreme Court directed that these guidelines must be strictly observed in all workplaces, compliance was very low. The Medha Kotwal Lely and others versus Union of India case, heard by the Supreme Court in 2012, demonstrates this. Goa, Gujarat, Himachal Pradesh, Orissa, Meghalaya and Arunachal Pradesh were found to have not made amendments to its civil service conduct rules. Plus, all of the above states, plus Jharkhand, Tamil Nadu, Nagaland, Manipur, Madhya Pradesh, Assam, Bihar, Rajasthan, Karnataka and Haryana had made any amendment to their standing orders. The court passed the direction upholding the Vishaka judgment and reinforcing the obligation for all states to uphold the guidelines set down therein. Whilst giving the Vishaka judgment, the Supreme Court recognized the urgency of the matter and urged the legislature to pass an appropriate form of legislation. Despite the recommendation, it was only in 2013 that the Sexual Harassment or the 2013 Act came into force. Thus, the Act took 16 years to come into effect from the Vishaka guidelines. The 2013 Act has largely adopted the guidelines that were issued in 1997. The Statement of Object and Reasons of the Sexual Harassment of Women in the Workplace, Prohibition, Prevention and Redressal Act from 2013 recognizes the protection to be accorded to women against sexual harassment as a human rights issue. This is fortified by India's commitment to upholding the constitutional provisions and from its obligations drawn from CEDAW. The Act largely adopts the guidelines in the Vishaka case discussed above. Some of the salient features of this Act are 1. It recognizes the responsibility of the employer to prevent and prohibit sexual harassment in the workplace. 2. It calls for the constitution of an internal complaints committee within an office or institution or branch or of any organization having at least 10 employees. If there are less than 10 employees, then such a complaint can be made to the local complaint committee, which is set up at the district level by the government. 3. There is a penalty prescribed for non-compliance with the provisions of the Act, which may extend to a fine of Rs 50,000. The ambit of the 2013 Act is very wide. The following is the constitution of the ICC. The Internal Complaints Committee must have a presiding officer. The presiding officer must be a woman employed at a senior level within the workplace from amongst employees. There must be not less than 2 members from amongst employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge. An external member or someone from an NGO should also be present. This applies to the organised and unorganised sector. Some of the well-defined terms used in the Act are the definition of sexual harassment as given, which is in line with the Supreme Court's definition within Vishaka. This was discussed above. An employee means a person employed or a workplace for. An employee means any person employed at a workplace for any work on regular, temporary, ad hoc or daily wage basis, either directly or through an agent, including a contractor, with or without the knowledge of the principal employer, whether for remuneration or not, or working on a voluntary basis or otherwise. Whether the term of employment is expressed or implied and includes a co-worker, a contract worker, a probationer, a trainee, an apprentice, or anyone called by any similar name. An employer is also recognized as the head of any department of organization, undertaking, establishment, enterprise, institution, or office, or unit of such an other officer, as the appropriate government or local authority, as the case may be, may specify. Any workplace not covered under the subclause 1 and any person responsible for the management, supervision, and control of the workplace is also included. Despite the 2013 Act being so recent and having had so long to evolve before being enacted, it has significant shortcomings. The Act imposes a time limit upon the filing of a sexual harassment complaint. This is something that neither Vishaka nor any other case has discussed. Whilst the period to report within is 90 days, there doesn't appear to be any reason that justifies this short and arbitrary limitation. Additionally, the statute provides for the setting up of a conciliation mechanism by the very same body which, if the mechanism fails, is to be responsible for adjudicating the issue. The Civil Procedure Code clearly provides for a conciliation setup in general to be coordinated by a body separate from that of an adjudicating body. The Justice Verma Committee had made several strong suggestions against this in their report. Another provision which has also been tagged by the Verma Committee in its report is the provision for punishing those filing false and malicious complaints. There is a significant concern here that women who feel they do not have a strong case and fear being labelled a malicious complainant will not file a complaint, or that women who are unable to substantiate their complaint with enough evidence may wrongly be labelled and punished. Another strong criticism of the existing law is that it fails to create or provide for adequate compensation for a woman who has been a victim of sexual harassment. Whilst conditions have been enumerated that must be taken into account whilst deciding compensation, there is very little that falls upon the offender's role in compensating the victim. Also, since the Act states that compensation must be decided according to the income and financial position of the victim, there have been questions raised as to whether the lower paid employees will be compensated lesser for the same act of sexual harassment compared to higher income earning employees. This indirectly shifts a high level of vulnerability onto them. In another matter of the punishment itself, critics have pointed out that the Act is very vague about the quantum of punishment, leaving significant room for interpretation and inconsistency. Further, the Act only relates to employment relationships, leaving behind a whole set of scenarios in a workplace setup, which should also ideally be covered. The fact that the Act is not gender neutral has further broadened the gap between men and women and has completely failed to recognise the existence of sexual harassment against non-heterosexual persons or transgenders as a tool for oppression, intimidation and violence. It is also blind to the fact that many men are also sexually harassed at the workplace. Though some companies in their internal policies are making room for men to lodge complaints, these are sporadic and far between. Making the legislation gender neutral would not only help resolve this issue, but would also bring the Act into conformity with emerging global consensus and help to quell claims that women take advantage of the law and men have no remedy. Since the enactment of the Act in 2013, there have been an increase in the number of cases being reported. This is often seen as a positive indicator, as it shows that the Act's provisions are being utilised. However, without effective structures to hear the complaints, hope for successful resolution of complaints does not, unfortunately, inspire confidence. According to the National Crimes Record Bureau data, cases of sexual harassment within the office premises have more than doubled from 57 to 119 cases from 2014 to 2015. There has also been a 51% rise in sexual harassment cases at other places relating to work, from 469 in 2014 to 714 in 2015. Despite the rise of cases and therefore the increase in awareness of the law, there have been several high-profile cases showcased by the media that demonstrates that sexual harassment by powerful men within the workforce remains rife, and enforcement of the law remains weak. Some of the famous cases in the news demonstrate that things have not significantly improved after the passing of the Act. Examples include the infamous Tarun Tejpal case, where he was accused of raping a staff member of Tehelka magazine. Although the case was registered immediately, the accused was let out on bail within a period of 6 months. The managing director of Tehelka was also criticised for trying to hush up the complaint. The case of A.K. Ganguly was also a huge blow to the judiciary. He was a Supreme Court judge and one of his interns levelled a case of sexual harassment against him. Initially, the intern was scared to come forward and report the case. She instead wrote a blog about the incident of sexual harassment that the Supreme Court judge had subjected her to, and this received a sensational response. It was taken up by the then Chief Justice of India, who set up a fact-finding panel to ascertain the veracity of her complaint. When the former intern's allegations were investigated, no FIR was lodged and the case was dropped after the Home Ministry said that there was no evidence. Another example is the Doordarshan case. An employee of Doordarshan alleged that her supervisor in Patna had sexually harassed her. She alleged that the supervisor passed obscene comments, made physical advances, and sexually harassed her. She officially lodged a complaint in April 2015, and while her allegations were found to be true after an internal probe, no action was taken against the accused. The complainant was then transferred to another Doordarshan office. There are several such incidences with All India Radio, Greenpeace, Wipro, the Energy and Resources Institute, TEDI. There are several similar such incidences reported at All India Radio, Greenpeace, Wipro, and TEDI, the Energy and Resources Institute. It would seem that no sector is free for complaints of sexual harassment, from the private sector to the non-profit as well as the judiciary. The complaints seem to be many. Further, in terms of legislative changes, it was seen that, in addition to the enactment of the 2013 Act, the Criminal Amendment Act 2013 introduced sections 354A to D to the IPC. 354A being sexual harassment, 354C being voyeurism, and 354D being stalking. The Protection of Children from Sexual Offences Act also speaks of sexual harassment of a child. The Supreme Court of India has also taken steps to introduce the Gender Sensitisation and Sexual Harassment of Women at the Supreme Court of India, Prevention, Prohibition and Redressal Regulations from 2013. And the Women and Child Development Ministry has launched an online platform to enable women employees of the central government to file complaints related to sexual harassment at the workplace. This module concludes that a significant benefit of the 2013 Act has been that people are now talking about sexual harassment at the workplace much more than ever before, and women are feeling more comfortable and better empowered to demand workplace protection and accountability for their safety from their employers. Many organisations are undertaking trainings and writing internal manuals and establishing committees to try and ensure effective implementation of the legislation. They are also trying to make sure that the provisions are accessible to their employees. However, the efficiency and effectiveness of these committees is a significant question if the future full and effective implementation remains piecemeal and stigma and victim blaming continue to surround sexual harassment. Overcoming these and combating patriarchal attitudes which undermine effective implementation at all levels must now be the site of future efforts to uphold the rights to dignity and equality for women in the workplace. This module is now complete. Thank you.